from the treasurer's office, from the AG's office. And who was that? I think Senator Washington was about to ask, or was in the process of asking a question. I don't recall. Okay, so, well, let's just open it back up. Who have questions of the panel? And Laura, did you have any kind of like more formal just walkthrough, or you're just kind of here to answer whatever questions come up? Or
we were here to answer questions. I'm happy to provide an overview or do a walkthrough, whatever the committee.
well, how long would that? I mean, it would be relatively brief or not brief?
We could start with the high level and then
Yeah, why don't you do that?
perhaps-
Just give a big picture overview. I think that would be very helpful. And to the extent, people want to drill a little deeper, we can do that. So why don't you do that?
So with the amendments and the reprint that the committee has, what the bill would do is transfer responsibility and oversight of the Maryland 529 program and abolish the Maryland 529 board, both effective on June 1st of this year. The bill also closes the door to new enrollments in the prepaid plan on June 1st of this year. The bill establishes a process for receiving claims against the trust so that if a claim has already arisen based on the disclosure statement change in the earnings rate, the issue that all the constituents have been calling about, they would need to file a claim by the end of this year. And otherwise, they would need to file a claim within 1 year. The process would be the exclusive way to obtain a remedy. So someone would have to go through this administrative process in order to get any sort of settlement above and beyond whatever the treasurer determines, the rate would be. As a condition of accepting a settlement, someone would sign a release of all claims against the trust and would agree to roll over into another plan. So that supports the goal in the bill of phasing out the prepaid plan. There would be an opportunity for limited judicial review, but for the most part, the treasurer's decision would stand. So the way that it will work is on June 1st, the treasurer assumes responsibility of the program. He'll have to consult with actuaries and attorneys and decide what costs the trust can bear, and then make a determination about what rate should be applied to the accounts. And then the treasurer's office is going to have to decide whether to outsource the claims process or hire staff and run the claims internally. And then, the treasurer's decision about what earnings rate applied will have to be programmed into the software that runs the program. And then at that point, once the system is programmed, all 31,000 accounts will have full access to their funds. People can choose to stay in the plan as long as, they'd like to. But if someone wishes to roll over, they would have to go through the settlement process, and that would be their way out. The bill also authorizes the treasurer to delegate fiduciary duties. That would give him additional flexibility since he would now be the sole fiduciary. Previously, the board had shared fiduciary responsibility, but it will be all on the treasurer's shoulders now. So it would be helpful if you could have some ability to delegate some of the authority to others. The amendments also provide for additional.
Why don't we do that as you're going through? If people have questions on that point. So Washington.
Just that. Thank you. I see you want to create a deputy specifically for this. That's correct?
Correct.
And then what does delegate responsibilities mean?
So the AG's office has engaged an outside counsel firm that has looked at this issue, and that was a recommendation of the firm to give the treasurer some additional flexibility, specifically regarding the claims process, with the decisions that need to be made about the individual accounts. However, the treasurer is going to be the one deciding what earnings rate is going to be applied to the accounts, and that's the primary decision that he'll make as fiduciary.
And then in terms of contracting that out, part of the problem, or some of what we got from the last board, was that they hired a firm, and the firm handled a lot of the data. They said ended up handling a lot of the day-to-day management of the fund. So are there any, so I want to better on, I don't want us to repeat that again.
Right.
So is this structured differently? Does delegate or contracting out, does it allow for the sort of the wholesale contracting out that the last board did? Or is it kept closer and therefore, yeah.
I guess I would say I have a couple of thoughts about that. So the current contract with Intuition, which is the vendor that runs the prepaid, I guess that would be a decision the treasurer would make about whether to continue with that arrangement. The bill provides him with that flexibility to continue making that decision to outsource running. But in some ways, when you said if it's closer to home, previously the fiduciary responsibilities were spread across a board where there were representatives from state agencies, members of the public. Now it would be a little bit closer in the sense that there'd be one fiduciary making decisions about what's in the best interest of the account holders.
Okay, and so that I understand, so there's the fiduciary responsibility, and then there's the management and operations of the fund.
Right.
Right, and so that can also be subcontracted out or is currently being subcontracted out by a vendor. Is that
Correct.
Correct, okay. So again, I don't want to amend it out, but I just want to express a concern or have it on the record that we don't want this to happen again. And so that whoever the vendor is or whatever that structure is, just strongly ensure that they are paying close attention to what's going on and that they are responsive to the community. Okay.
Noted. Thank you.
Okay, Senator Carosa.
Mr. Chair, and thank you for allowing us to take this time to understand the process. And I'm a process person, so that's why please understand my questions. I understand that, the whole transfer of authority to the state treasurer. Then you have this claims process set up. But my questions are, first, I want to understand, you mentioned a process before you get to claims of what the state treasurer has to determine. So I want to understand that. And two, I want to understand with this new process in place, and it looks to me that it's incumbent upon the parents or the individual to file a new claim, regardless of whatever their past interaction was with the 529. And I want to be very clear on that because we have a lot of parents who believe they have already spent a lot of time and blood, sweat, and tears just to this point. So I think if what we're saying now is we have a process, you can officially file a claim. How do we still make that process, customer friendly? And then two, will each one of those claims be reviewed on an individual basis as opposed to, oh, we kind of did a sweeping generalization and you fall into that category?
So the reprint has provisions that says that the treasurer within 10 days of adopting the procedures that will govern how someone files a claim and what the claims process will be, within 10 days of establishing that process, the treasurer has to notify all of the account holders of what the steps are that they need to follow to file the claim. And then that was to your first question.
You would even do the claims.
Right, so
You said
yeah.
something about the treasurer has to determine, and
So the issue and the reason why the account holders are upset is because they were told that their account balances reflected a 6% earnings rate applied back to when the accounts were opened. And what the board had intended was that the 6% apply prospectively from November 1st, 2021. So there's a discrepancy about what the earnings should be on the accounts. So the treasurer's first order of business is determining which earnings rate should be applied on the accounts. And that is going to inform the settlement amounts for all of the account holders.
so once you have those general and then you would apply that specifically to the individual situation.
Yes, and to your second question, it will be an individual account review, applying whatever the earnings rate is to each account, and then that will be what the settlement is for each person.
So
And
there'll
it'll
be
vary.
fairness and consistency on that, but
Yes.
it sounds like the heavy lift is on the front end to determine.
What the trust can bear.
Okay, Senator Hester.
So I just want to make sure that I understand that correctly. So does everyone then basically file a claim?
Yes, we're anticipating that some will file a claim, but I believe to date, it's been about 800 people that have requested a manual account review, and there are 31,000 accounts. So more than 800 may pursue a settlement, but there will be a number of account holders that will want to remain in the trust because they have already, they like the program, they want to continue with their contracts. So we're not anticipating that all 31,000 or even close to that will pursue a remedy through the settlement process.
So those that don't file a claim, they will get they will receive the same like interest that you were just talking about?
Yes,
Okay, and then on page 5 of our sheet, which the amendments says, point number 2, for all other claims, 1 year after the date the claim arises. So
Mhm.
that's claims not related to this issue we're talking
Future
about.
claims, if there were a
Fut-
future issue.
Okay, and that would be after the, for all other claims, 1 year after the date the claim arises. That feels like a circular reference. Can you just explain that to me? They basically got a date, a year from the date of the incident?
Right. So in this case, I think maybe the AG's office could speak better. They had sort of tiered it and written it this way because this is going to be a part of the statute. And now this will exist for if there's a future issue, there will be a settlement process in effect. But
That's exactly correct. So
Get the mic up there.
I'm sorry.
Yeah.
That's exactly correct. The claims process is being designed to take care of this problem, balancing the interests of both the plan holders and the assets of the trust. If there is an issue in the future, and that's where or a year comes in. We're talking about the file by the end of the year for the present claims that we know about. And then if there is a basis for a claim at some point in the future, it has to be filed within 1 year of whatever the basis for the claim
Okay.
is.
I mean, I'm not a lawyer. I really wonder if that too is drafted correctly, but that's fine.
Okay, now's the time to get all these questions out. Any additional questions for our panel? Senator Simoner.
Thank you for taking our questions. I tried to read the 42 pages really quick. I see there's a current report annually by the board in current law. Is there anything in here that will report back to the governor and the General Assembly of the actions taken as a result of the new actions for the treasurer? So we're kept in the loop.
there's nothing in the legislation that would require that. However, I know that communication is the treasurer's priority, improving communication and working closely with the legislature is of the utmost importance to him. You all elect him. So, I will certainly relay to him that that is a concern and a priority of yours as well. But I would say that's a shared priority.
Okay, whether it's a letter written or whatever, I think we should get something back at the end of the year to see how this is progressing because it's affecting a lot of our constituents. Is there anything as far as outreach that the treasurer is going to do to make sure everybody knows that they have this opportunity and what the timeline is associated with that?
I was actually just speaking with the treasurer before we came over, and I wouldn't want to box him into anything, but that's on his mind as well. And he mentioned radio ads and really trying to make sure people understand that they would need to file a claim by the end of this year. It would not serve the treasurer's office or the program to have a settlement process and people miss the opportunity and then they're upset about that. So
And I agree with that because this bill, I think, is setting up a deadline that they have to make the claim. And if, just a simple letter going out to each person would help with that. I think that's all I had.
Okay, Senator Brooks.
Thanks, Chair. Laura, is there anything out there to show how much money we're talking about, how much, what the investments were, what was the obligation liability? What's the growth? Is there like
Exposure
a
to
balance
the
sheet?
trust.
Yes.
The
Something.
529 program has been working closely with their actuary, and we're anticipating a report by, they said mid to late April, which is not helpful for session, but they are looking at figuring out with some precision what the potential exposure is. And that is what's going to be a big part of the treasurer's decision that he has to make, is looking at the assets of the trust and making a decision about,
Mhm.
expenses and what the trust can bear.
Right, and that'll also show, I guess it'll show what was invested. And then at the same time, what the growth was, and just show, just show what the total assets are.
Right.
Yeah, okay, all right, thanks, Chair.
Okay, additional questions? Okay, seeing none, when we left for our 10-minute or 15-minute break, we did have a motion to move the amendments on the table, and we had a second from Senator Washington. Any discussion on those amendments? Senator Hester, could you, where is Senator Hester? Okay. Yeah, we're taking up the amendments. We got a motion in a second. Any discussion about the amendments before we take a vote? Okay, this is an important piece of legislation. We have a motion second. Let's do a roll call, just so there's no ambiguity on this one. This is on the amendment package.
Yeah, all right, Senator Kagan,
Aye.
Senator Kagan, yes. Senator Augustine.
Yes.
Senator Augustine, yes. Senator Gallion.
Yes.
Senator Gallion, yes. Senator Watson. Senator Watson, yes. Senator Lewis Young.
Yes.
Senator Lewis Young, yes. Senator Brooks.
Yes.
Senator Brooks, yes. Senator Carozza.
Yes.
Senator Carozza, yes. Senator Hester.
Yes.
Senator Hester, yes. Senator Washington.
Yes.
Senator Washington, yes. Senator Simonero.
Yes.
Senator Simonero, yes. Senator Feldman.
Yes, the amendments the motion carries unanimously. Now we have the legislation. So Senate Bill 959 as amended, we have a motion and a second. Augustine, Kagan in the second spot. Okay, based on that, let's all in favor, raise your hand. Okay, all opposed, bill carries unanimously. So thank you, folks from the Treasurer's Office. Tell the Treasurer we said hello and good job. Okay, let's go back. Before we go back to the voting list, we have another concurrence has popped up. So we're going to go to Stacy for a concurrence.
Sure. Senate Bill 263, the Maryland Higher Education Commission Access to Mental Health Advisory Committee Establishment. In general, you recall this bill establishes the Access to Mental Health Advisory Committee within the Maryland Higher Education Commission. On the cross-file House Bill 573, the House had added 3 student members. This committee agreed with that amendment for House Bill 573, so the House has added that to the cross-file Senate bill. So the motion is to concur.
Is there a motion? Motion from Senator Kagan, second from Senator Lewis Young. Discussion, all in favor of the motion to concur, raise your hand. All opposed, motion carries unanimously. Okay, Robin, why don't you come back up? Where we left it, we were on Delegate Boyce's House Bill 266, and you were explaining what portions of the House amendments the nurses didn't like and did like, and that's kind of where we left things. Yeah.
Thank you. So Robin Elliott, still with the Maryland Nurses Association. And we were happy with the House bill as it came over. We thought the House did a great job. There were a few small amendments suggested by MDH and Board of Nursing that you all could take up. The core amendment in the reprint in front of you that the nurses have concerns about are the administration of inhalers to kids who've not been diagnosed with asthma. And happy to answer any questions. And you've all probably got some emails from the nurses as well as MDH and MEMS, the pediatric nurses, the emergency nurses, and the school health nurses on this issue.
Okay, Vice Chair Kagan.
Chair. So Robin, thank you for being here. During the original hearing with Delegate Boyce, I asked why it was that we had to wait until a second possible asthma attack and why it was that the bill said subsequent, like after it's been diagnosed. And you explained it to me, and I think I got it, but maybe to help me, and if there's anyone else who found it a little confusing, why not from the first option, first incident?
Thank you. It is a little confusing, but essentially asthma and anaphylaxis can have the same symptoms. Thank you. Plain language, it's a food allergy. So commonly with kids, peanuts, almonds, that kind of thing. So a kid is exposed to a peanut, doesn't know, no one knows the kid has a food allergy. The symptoms can look very similar, exactly like an asthma attack. So if a bronchodilator is used instead of an EpiPen, an asthma inhaler, or a buterol, as some people call it, that would delay treatment of the food allergy and potentially endanger that child. So that's the core concern that the nurses have.
Put into plain English, super plain English. Kid is can't breathe. Looks like it might be asthma, but it could be a food allergy, and maybe Senator Gallion, maybe it's sesames or sesame seeds, and we wouldn't know the difference. And so well-meaning folks might not know how to react. And if that child were given an inhaler, the symptoms might abate. So the gasping for breath wouldn't happen, but the allergy would not be addressed because the breathing passages would be ameliorated, would be widened, would be like they could breathe. And so then you think, oh, good, it was asthma, but maybe it wasn't. It was the sesame or the peanut allergy. And then
the child would be at great risk of anaphylactic shock or the food allergy. The worst case scenario is that the children can die, but there are other serious implications.
okay, so let me just stay with that same thing. So now the first time the child is gasping for air, we don't know whether it's asthma or a food allergy. Nothing is done except the child gets taken to the emergency room, gets what? How does that child get addressed?
So the current protocol is that an EpiPen is administered and then 911 is called. EpiPens actually work for either food allergies or asthma. And then obviously super important to make sure that there is follow-up care provided to that child to figure out what the underlying problem is. And that's something that school nurses work to do, making sure that child has a primary care provider, or if not, making sure that linkages happen so that it doesn't happen again, whether it's asthma, a food allergy, or any other health issue.
Walking me through this, and I appreciate this. This is helpful. So the first time the child is given an EpiPen, which if it's column A or column B, either way, the child is helped with an asthma attack or a food allergy. The child is then taken to a doctor, an emergency room, 911 is called. The child then gets a diagnosis. And so we know from here on out, the child either has asthma or has a food allergy or something. So we're talking, this bill addresses the second or subsequent time.
Yes.
So the next time the same child is gasping for breath, and let's say it's asthma or either one, whatever, however you want to do it. I don't have my inhaler with me. We can't afford an inhaler. We can't, like, how does that work? And then again, can EpiPen be used a second and subsequent time? And can an EpiPen be used without parental permission? Like, are there consequences to that, related or unrelated to this bill?
So an EpiPen can always be used to treat asthma, but if the child has a prescription, that is certainly kind of a sort of more tailored way to address asthma. What the bill does is has stock bronchodilator programs. So schools have to have a cabinet locked full of inhalers. And then if the child has forgotten their inhaler, which happens, it's kids, or it's expired, or some families can afford to provide an inhaler at home and an inhaler at school, and some families can't. In any of those scenarios, if the child has a prescription and that inhaler isn't available for whatever reason, the stock bronchodilator can be used. And so this is, that's what the bill in essence does, that came over from the House.
We have one more question. The child's diagnosis is shared with the school, and so the school nurse or the whomever will know that this child is presenting as asthma and not a food allergy, or vice versa?
Yes. So each child that needs any kind of medication has a health plan that is signed by the parents, also authorized by the child's provider, whether it is an asthma plan or any other medication. I think Senator Watson may have asked me that question during the hearing. But it's a plan that the parents and the provider all assign to and work with the school health nurse on.
Okay, Senator Carozza. Oh, Senator Washington, then Senator Carozza, sorry.
I have a question about, I understand, one, I want to make sure and support the idea of having more of these bronchulators available in our schools. So one, I like that part. But it's my understanding that there aren't equal impacts. If you give, and I'm not a physician, but my understanding is that if you incorrectly diagnose or you give a student, if you think a student has asthma and they don't, and you give the bronchulator, then it's okay. But there's another scenario where if you give it to them, it delays the response. It delays the symptom, but it actually delays response of the actual harm. So there's a concern about being able to give this to children when you don't know the diagnosis. I think that's the issue, right? And so I'm just trying to make sure I understand that. So which does the House version, does the version that we have with us ensure that reduces the likelihood that will happen, or yes?
Yes, Senator Washington, and that was very good for a physician coming from a non-physician myself. So I think you got it exactly right. The House bill helps children who have a diagnosis to make sure that if they've forgotten their inhaler or their parents can't afford a second one for school, that an inhaler can be used in an emergency.
Situation in which someone who doesn't have a diagnosis and they have some other type of respiratory that has a negative reaction to that there is that risk, in other words, that would happen. Is that also a nursing and physician concern, or no?
Yes. So the bronchodilator itself doesn't have a lot of sort of bad side impacts. The issue is exactly as you said, that it can delay treatment, and it's particularly problematic when we're delaying treatment for children who have food allergies.
That's it. So right. So it would get rid of the symptoms. And so you think that they're okay, but really they're reacting to peanuts or something else. And so you don't do that intervention. Thank you.
Okay, Senator Carozza.
Thank you, Mr. Chair. And I think the Vice Chair and the Senator Washington's walking through those scenarios was very helpful. And just trying to understand literally what's in front of us. I know our former colleague, Senator Addie Eckerd, who is a nurse by background, did she share some of her expertise on what's in front of us, and what are we basically cherry picking from these amendments to move forward, just so we can move forward?
Yes. Thank you for that question. And for those of you who don't know, Addie Eckert is now Legislative Committee Chair of the Maryland Nurses Association. So it's really wonderful to be able to work with her in that way. And we absolutely looked at the House bill as it came over, line for line. She's got, as you all know, a long history of really supporting school health nurses. And she felt very, very positive about the bill as the House sent over. Mhm.
The Maryland Department of Health amendments, or we're adding those?
Those amendments were those amendments were small, like reporting date, change in reporting date, and those kinds of things. So the nurses are really okay with or without those amendments.
But like the House version that came over.
The House version that came over is the version that the Maryland Nurses Association, as well as I think the other clinical stakeholders like.
Well, thanks for that update on Senator Eckert.
Yes.
Okay, Senator Hester.
Well, I asked a question also during the hearing about, and I even asked Delegate Boyce about how the bill came over from the House. And I have concerns about the way it came over from the House. And I followed up with Christy Sadramelli, who is assistant professor in the Department of Pediatrics and also a pediatrician herself. And I shared this with committee counsel, and also I don't know if committee counsel sent it to everybody, but I asked her how the laws were written in other states, and she attached a publication from 21 detailing the laws or regulations in 15 other states. And since then, Virginia and Iowa have also passed laws. So we're up to 17 laws now. Of the 17 states with laws or regulations, only 4 currently restrict the bill to diagnosed asthmatics. So that the 4 that restrict it are Missouri, New Hampshire, Texas, and Utah. And she goes on to say that of note, there are 3 states with restrictions. Of the 3 states with restrictions, Texas feels that the bill has been ineffective and they're amending it to take out the diagnosis restriction. And she, at the time she wrote this just Tuesday, I don't know when it was, but she said in the past 1 to 2 weeks, in Texas, they've gone through this process. And it would be great if Maryland doesn't have to go through the process in the future to fix the bill the way Texas is doing it now. So once Texas moves over, then only 3 of the 17 states will have this restriction in that. I'm happy to share this article with everybody, but I had reached out to committee counsel, sent this article, said, hey, is somebody drafting amendments? Because I would like to propose an amendment to take it back closer towards the House version. And I did not prepare amendments because I was to that effect, because I was told that somebody else was doing it. So I just. Right, but it sounds like you're not going to offer all of your amendments. And so I don't know, I feel kind of, I feel disappointed that I was not clued into to
Okay.
it.
Well, here's the thing. Okay, I know, we spent a fair amount of time on this. We had a whole, it seems like we're kind of maybe getting close, but there's still a little ambiguity. I might suggest we will be voting again tomorrow, that we just do that again, because I think we flushed out. I think we've narrowed the issues. I think there's an understanding of sort of what's going on here. So I'm going to suggest maybe you could speak with Senator Kagan and anybody else has any questions, and then it'll be the first bill we take up when we start voting tomorrow. Is that okay with everybody? Okay.
100%.
Yeah. So let's rather than have a debate here. Thank you, Robin, for your
Thank you.
input, and we will take this up first time when we meet tomorrow after session. After the picture, this will be. We'll okay. Let's go next to House Bill 323. Delegate Charkoudian.
This will require a little bit of circling back to make sure that I'm closing the loop on a fiscal note. So if we can pause on this one.
Okay, so we're going to hold 323. Next up, House Bill 480, Delegate Rogers, and this is a cross-file of Senator Simon Ayers' bill.
Yes, so House Bill 480, Department of Veterans Affairs, Burial and State Veteran Cemetery, Spouses and Dependents. This is identical to Senate Bill 286 that we amended. And essentially, it requires the Department of Veterans Affairs to issue a grave liner without charge to either the veteran, the spouse, or the dependent of an individual that is buried in the state veteran cemetery. So we would pass this clean if we would like it to conform to the Senate version.
Okay, Senator Simon Ayers, do you have a motion? Okay, I have a motion favorable from Senator Simon Air, second from Senator Brooks. Discussion? Okay, all in favor of the clean version of House Bill 480, raise your hand. All opposed, that bill carries unanimously. Next up, Delegate Amprey, House Bill 624.
Sure. So I'm gonna distribute here. So Delegate Amprey did send out amendments shortly before the voting session, which you should have received, but this is just the reprint of those amendments is going around. So this bill was on our voting list yesterday, but was held. As a reminder, this bill alters provisions governing notice requirements applicable to a water supplier when a water system is not in compliance with state drinking water regulations. The amendments limit requirements that notice be given by at least 3 methods to acute tier 1 violations that have a significant potential to affect human health. The addition that has been made since yesterday to that provision just specifies that that notice has to be given in accordance with Federal Safe Drinking Water Act. The amendments also require water systems to provide notice to the Department of Emergency Management and the Department of the Environment when there is a confirmed positive test for total coliform and a repeat test sample from the distribution system following a confirmed positive test for E. coli in a routine test sample from the distribution system, and then adds language regarding the direct delivery of certain notices to say that direct delivery shall be by mail or otherwise, and shall go to each customer receiving a bill and each service connection to which water is delivered. Those are the amendments and those are the changes from yesterday.
Questions for April? Senator Augustine.
Thank you. I think that I know I received a letter from Baltimore City saying that there were certain changes. Is that what this is? Are these those changes?
I believe so. I didn't actually get that letter.
Oh, you didn't receive the letter? Okay, well, I think that was that. And that was obviously I'd asked a question about how the locals felt and everything else. And the second thing I just want to put out there, April, and I did talk to Delegate Amprey about this, is on, as I had mentioned in our last session, on the 4th page at the very end, where it says the institution of higher education would have to send it to the parents or legal guardians of all minors and students regularly served by the water system. I spoke to the delegate and his intent was, that basically if it went to the students at the institution, that would be it, versus a reading of this, which would suggest that the water company would have to find out what the students' parents around the country would be. And so I'm not sure how you would, change that a little bit to be able to do that.
Yeah, I mean, we could do that through a conceptual amendment.
That's what I'm
clear
saying.
that up. Yeah.
Okay.
Just to be clear, be conceptual, you're talking about on page 4, this language, the parents or legal guardians of all minors and students really served by the water system, like that portion.
I'm talking
is
about that. So that
yeah.
says that the water company just has to tell the student and at the university, like it's not that they have to find the parents all over the country or, information that they may not have.
And I think the way that would look would be take the institutions of higher education totally out of this, item 2, and instead just create an item 3 and say, if the water system serves an institution of higher education, the students regularly served by the water system.
Good. Yeah. And so, and I know that I see from in here, Senator Washington has something different, but with that, we can still have conversation, but that I think kind of settled on.
Okay, let's put that a conceptual
side.
idea
Yeah.
here, and then
Just wanna
let's
put it out
hear
there.
everybody else. So Senator Washington, yes.
And I fully support and get the intent of the bill sponsor, and I've attempted to have conversations about it. One thing, colleagues, is that very specific, so there's very specific regulations already exist in our code. Under 26-040119, and it was most recently updated in April of 21, that regulates and says what's supposed to happen exactly when it comes to what water suppliers are supposed to do. And there's a number of things. Some of this appears to have been codified over the years. But again, it's what I read when I look at the regulation, and specifically it talks about E. coli violations. It talks about reporting to an authority. It references the tier 1, which again is the federal code. There's not a need to put this, in law. It's already in federal law, and that law is referenced very specifically, in our code. The situation that that this bill sponsor is attempting to address has to do with the compliance, I believe, of the federal regulations, and also so it is duplicative of law. So I feel like the bill itself is not necessary. And the things that need to be fixed are not addressed in the bill. For example, in the bill, it says to get rid, well, it's on page 3, lines, it would be 17 and 19, where it says if there's a positive test for E. coli in a distribution system, which I don't know what that is, the supplier of the water for the system shall immediately begin preparations for issuing a boil water advisory. But then we tell them to begin to prepare for issuing it, but then there's no follow-up about issuing it. So I think that the bill is not, I'm not comfortable voting it in its current posture. If we want to codify regulation, the reporting requirements, we could do that. But some of these things, in my humble opinion, sort of are less than and not as rigorous as what we already have in code. And I think it's about having water systems be accountable. And this bill doesn't do that. So I just wanted to share my colleagues, either we hold it or we do it as a summer study. But I don't think, and you can also read the favorables with amendments that would really want us to do more.
Sarah, could I just suggest one thing? We do have MDE here in the
Yeah.
room. It might be helpful for the committee. We have Sarah Augustine talked about conceptual. You said the bill's unnecessary, and MDE I had input. Who's here from MDE? Yep. Yeah, right there. Okay. Why don't you guys come up so that the committee can take advantage of the fact you're here and you heard some of the commentary, and give you an opportunity to respond, and then we'll just see where we land. Okay. Tell us who you are.
Les Knapp on behalf of MDE.
Gabby Leach on behalf of the MDE. I guess on the comments, I think the intention of the bill, like what Senator Washington was saying, is to further, I think, the transparency and communications, and as a result of what the constituents were saying over the summer. And so MDE has been working with the bill sponsor just to make sure that it is in line with what federal regulations are, and then also with what is currently in statute. So
I guess my point is that it's in regulation, Is there anything in this bill that's not in regulation, and can we perhaps put it in regulation? Or you could put it in regulation. And then if we wish to codify a more package, because the other thing that I note about this section, it seems specifically interested mostly in our non-educational public schools, family childcare, and childcare centers. And perhaps we need another section that is specifically about the public. It seems to be amending a section that wasn't really necessarily designed for the public. Would you?
So
That's.
I can't speak on that piece
Yeah.
of the bill because that's not what we directly worked on, but I will say, I guess, the 3 means of notification for those utilities that are higher than 3,300, that's not currently in statute. And I think that's why we want to make sure there was multiple ways of getting out to constituents.
Can you put that in regulation?
Yes.
Yeah, you can,
Yeah.
right? We don't need a law for that. Okay.
Okay, we got
right.
Senator Hester, then back to Senator Augustine. Senator Hester?
I mean, I like the idea of the additional ways of notification and agree that it could be in regulation. My concern was that it seemed like this bill was less, had fewer requirements than the federal EPA law. That if you look at a tier 1 E. coli outbreak, it says unequivocally in EPA that it's got to be 24 hours of reporting. And this bill says 24 hours to 30 days. And that makes me, a bit nervous. So I wanted to make sure that I was interpreting that correctly.
I don't think that was the intention of, I think, and maybe I can maybe get back to you on that, but I don't think that was the intention of it. I think our amendments were trying to keep it consistent with the federal.
I'm not sure it's
Yeah,
drafted correctly.
And we could not even, MDE could not enact standards less strict than the Federal Drinking Water Act. So what we were attempting here to do was the Federal Drinking Water, Safe Drinking Water Act is the floor, the base, and then the bill added a couple of extra additional requirements on top of that. We can look at your one particular issue, but that was the intent of drafting these amendments.
Okay, so we're on the same page with the draft that we're not going to go below EPA, but it doesn't seem like it does that much more beyond the EPA, except add these two things which you can do, in regulation, which I think would be a great idea to do. But my other bigger concern is that I think the issue is one of enforcement, and a couple of the stakeholders pointed that out. We can pass as many laws as we want, but if nobody's enforcing them, and does this bill currently have any teeth for enforcement in it?
So I think that was one amendment we were trying to clarify a little bit more, was clarifying the enforcement piece. But I think at this time, I don't have the bill exactly in front of me because I ran over here, but I think there is currently under the statute that it's under, and Les might know a little bit better, that there is currently enforcement, but we wanted to build upon it, but it was a little bit too much with where the bill was moving and so forth. But yes, there should be enforcement already under the statute of what it's under. Yeah.
Yes.
Okay, Senator Augustine?
Yeah, my light wasn't on, but I'll speak. That's okay. So what I would say though is that isn't it true that we do put into statute things that can be done by regulation to just demonstrate the legislature's intent and its desire to make clear that this is something that we do. I mean, I feel like we do that. That is something that we do. So I don't think that in and of itself is a reason for us not to do this. I just want to put that out there, even though I really didn't have my light on.
Okay, I thought you did, but yeah. Yes.
I'm saying if this was a codification of existing laws and was was doing that and it was comprehensive, it just seems it's very piecemeal. And if we're going to do that, we should be doing it in a more comprehensive way. So then, yeah, so again, folks can vote as they choose, but I think that perhaps rather than voting it down or something, that maybe we voted as a summer study and we do, we come back with the bill sponsor and really address the issues that are raised, by I think that the agency we can work closely with this agency and develop a larger piece. Again, this section of the code has to do with notifying schools and family care homes. And that's why simply adding in an institution of higher education doesn't really work. And I don't think just simply adding in these notifications, just taking out tier 1, well, why not put in tier 2? And adjusting for certain situations. And that, again, we're not taking all of the code. It's just
Here's-
simply
here-
one piece of it.
Yeah, okay. Well, one comment
Make it
as far as this, putting in statute versus regulation. Sometimes the reason we do it is regulations can be changed from administration to administration. Statutes are much more difficult. So sometimes we do it for that reason, but that aside, there seems my sense is that we're not quite ready to take a vote on this one. So we're going to hold this one along with the other 3 we've done so far on this list. And again, we'll roll this in tomorrow. In the meantime, we'll have some conversations and figure out maybe the path forward. But thank you guys for coming up and helping us out here. Let's go to the Prince George's. There's a Prince George's delegation bill, House Bill 1026. Alexis.
House Bill 1026, Prince George's County Land Use Development of Neglected Property. This local bill gives Prince George's County the authority to exercise the power of eminent domain on neglected property in an area that has been designated as a transit-oriented development and in a property that's located in a business development district. The amendments from the Senate delegation remove residential from the types of properties that may be designated as neglected and clarifies that public use, which is the only use contemplated within this eminent domain taking, includes private development that serves a public use.
Okay, any discussion, comments from any of our Prince Georges? Okay, we've got a motion from Senator Augustine, favorable. Senator Watson, are you too? Okay, any discussion? Okay, House Bill 1026. There's no amendments, it's clean.
Oh, it's an amendment.
Okay,
Yep.
there is one
It's
amendment. What's the
included
one
in the
amendment? I'm sorry. I
packet.
apologize.
So the amendment strikes residential uses from
Okay.
the definition.
Okay, so we'll count those motion in a second on the amendment.
Yep.
Okay, everybody got that amendment? Okay, all in favor of that amendment? Raise your hand. All opposed, that amendment carries unanimously. We're gonna now go HB 1026 as amended. Senator Augustine, Senator Watson, are you a second on this one? Okay, discussion. Okay, all in favor of House Bill 1026 as amended, raise your hand. All opposed, that carries unanimously. Let's go now to the next page, and we'll try to discuss these final 4. House Bill 1046, Stacy, 1047, I'm sorry, Stacy.
So this needs to be held because the amendments are not ready for this.
Okay, we're gonna hold 1047. Next up, 1051, Alexis.
House Bill 1051, Public Information Act, Decisions of the State Public Information Act Compliance Board Appeals. The bill authorizes a government unit or person who has been aggrieved by a final judgment in a circuit court that pertains to decisions issued by the State Public Information Act Compliance Board, gives them the authority to appeal specifically to the Appellate Court of Maryland for resolution after that circuit court issue.
Okay, Senator Kagan has moved favorable. Is there a second? Senator Watson? Yes, question from Senator Augustine.
Were there amendments on this?
No,
It
she
was clean?
signed up as favorable with the amendment, but it looked like in reviewing the testimony, that was the amendments from the House.
Oh, is that what it
Yeah.
was talking about?
Yeah.
Okay, very good. Thank you.
Okay, so we have a straight up favorable motion and a second. Any discussion, further questions? Okay, seeing none. All in favor, House Bill 1051 clean, favorable, raise your hand. All opposed, House Bill 1051 carries unanimously. Next up, House Bill 1200. Stacy.
House Bill 1200, Elections, Election Judges, Minimum Compensation. This bill establishes specified minimum compensation levels for election judges, including higher minimum compensation for returning election judges. There is one amendment in your packet on page 30. And this amendment would require the state to reimburse the local board for 50% of that higher minimum compensation for returning election judges. The bonus payment is $100. The state would reimburse them $50. The state board must also develop a marketing campaign for the recruitment of election judges and distribute this to local boards for their use.
Discussion on the amendment or the underlying bill? Yes, Senator Kagan.
Just briefly, colleagues, the amendment, as you may, those of you who were here last year may remember that we had an emergency bill that became law that required that election expenditures be divided between the state and the county so as not to have pass along unfunded mandates on election stuff. And it was 50-50. So we've been in conversations, and this would be a very modest for both sides, frankly, but in keeping with our principle of trying not to do unfunded mandates, it would give a little bit of support for our counties as we are telling them that they have to pay their judges more. So if they're not doing 250, and let's say they're doing 200, well, to use Stacy's example. So if they're paying 150 now, and we're telling them they have to pay 250. So the state would pay $50 of the $100 increase. And the other piece, not every county has the resources to do graphics and to create a marketing campaign. And we know that it's really hard to get people to become election judges. So rather than doing it 24 times, it made sense to me to just ask SBE. They already hire consultants and stuff on marketing. So let's have them create just simple graphics, simple something marketing. And then if Dorchester County wants to use it, bully for them. And if Garrett County doesn't want to, then they can ignore it. So, but everyone would be given a copy, and that would also save them some money and give them professional looking, nice stuff that they can use however and wherever they'd like. So I would move my my amendments.
Okay, well, just, the Kagan amendment, I'm looking at page 30 of the packet. It's in the back, 30 and 31. Senator Carozza? Yes.
Thank you. And I'm just coming up to speed on this. So do we know where our local boards of elections are? I don't know if that was in earlier testimony or if they've had a chance to look at these amendments.
I can tell you that I talked to Katie Berry of Carroll County with Maryland Association of Election Officials, and I think election officials appreciate financial support when it can be given, so it's not an unfunded mandate.
Okay, additional questions before we discuss further discussion of the amendment? Questions for Senator Kagan, sponsor of the amendment? Okay, you moved your amendment. Is there a second on the Kagan amendment? Senator Brooks, further discussion on this amendment? Okay, all in favor of this amendment, raise your hand. All opposed, amendment carries. We've got House Bill 1200 as amended in front of us. Is there a motion?
As amended.
Motion favorable on the bill as amended from Senator Kagan, second from Senator Brooks. Discussion, all in favor, House Bill 1200 as amended, raise your hand. Okay, all opposed. Okay, I believe that carries unanimously. Okay, wait, let's leave it here. Okay, no confusion. Okay, roll call. No, I'm sorry. What'd you say? Oh, wait, no. Well, there was a little, people didn't raise their hand. Okay, we have House Bill 1200 as amended. Let's take a roll call.
Senator Kagan.
Aye.
Senator Kagan, yes. Senator Augustine. Yes. Senator Augustine, yes. Senator Gallion. Senator Gallion, no. Senator Watson. Senator Watson, yes. Senator Lewis-Young.
Yeah.
Senator Lewis-Young, yes. Senator Brooks.
Yes.
Senator Brooks, yes. Senator Carozza. Senator Carozza abstains. Senator Hester.
Yes.
Senator Hester, yes. Senator Washington.
Yes.
Senator Washington, yes. Senator Simonaire.
All Republicans are represented here. I'm gonna say yes.
Senator Simonaire, yes. Senator Feldman.
That carries 9-1-1. 1 no, 1.
My hand was up for something else. So.
Oh, I'm sorry.
No, but
Yes,
Looks like we haven't done anything with Senate Bill 925. I know it's late.
we have not.
Yeah,
I know it's late.
no, true.
I mean,
Agreed.
because that was what I was raising.
Oh, I apologize.
So that's the
Okay.
first thing. Senator Washington, other Washington, Senator Alonzo Washington has this bill, but we have to do the House one first, but
No,
totally.
I know.
Okay.
I was saying we
Yeah.
did it and I just want to make sure.
No, okay.
I'd like to move the.
Okay, wait, okay, but wait, before we do that, the bill carried 9-1 yeas, 1 no, and 1 abstention. So the bill carries. Now, Senator Augustine, we've got Senate Bill 925. Do we have to, can we do just our motions to conform kind of thing, or is that appropriate here? Okay.
Motion to conform.
Okay, to conform. Senator Kagan. Okay, so we're on Senate Bill 925. All in favor of moving to conform 925 to what we just did on House Bill 1200? Okay, raise your hand. All opposed, that carries unanimously. And everybody's vote will count as the same, Lemuria, on Senate Bill 925. Okay, which brings us to our final bill of the day, House Bill 1237. Stacy.
House Bill 1237, Special Education, Judicial Actions, Attorney's Fees, and Related Costs. This bill authorizes a court to award a reasonable attorney's fees and related costs, including expert witness fees and costs, to the parent of a child with a disability if the parent prevails in a proceeding that is held to resolve disputes about the identification, evaluation, or educational placement of children with disabilities or the provision of a free, appropriate public education or FAPE. However, such an award may not be made after the date a written offer of settlement is made to the parent under certain circumstances, unless the parent was substantially justified in rejecting the settlement offer. There are no amendments.
A question for Senator Augustine.
Both MABE and MAJ are against this. Is that correct?
Correct.
And this is still the case.
It is the case because the federal law allows for the collection of reasonable attorney's fees, but it does not allow for expert witness fees. And as John Willems from the Maryland Association of Boards of Education, MABE, said, they don't support that.
Right, so if you recall, the two witnesses unfavorable were John Willems and George Tolley from MAJ. That is accurate. I mean, we obviously, there was a lot of, I remember specifically Senator Watson pressing on the issue of expert witnesses. So yeah, so that's kind of where things are, and this is one of those bills. Let's further discussion questions. But first of all, are there any amendments or straight
no
up
amendment.
bills? So this is going to be yes, Senator Washington.
I want to move favorable on the bill. Yeah, are we already moved favorable? Okay, I wasn't sure where it didn't sound like it. Okay, so I want to speak to, I do think I'm ready to vote. I hope we're ready to vote. It's fairness. It's, yeah, I just think that it gives parents an opportunity to be, to consider advocating for their children, having the expertise, having an expert witness is a part of that cost. And if you're not able to have someone justify your claims, then it's less likely that you're able to prevail. Now, if your claims are not legitimate, there's still a judge that's there. There's still a lot. So I think it just evens the playing field in this regard. So.
Okay. Actually, I don't recall that there was a motion favorable.
Yeah.
It was,
Just to
okay, I
make
apologize.
sure that this is only if they prevail. Okay, I just, the witness as he spoke, didn't often say that, but that is a condition of that. And this can also be taken back if they're offered a settlement in a certain period of time and they reject that settlement thinking they'll get more later on, they could still lose the opportunity. So it's not a full, just to be absolutely clear about what's in the bill.
Helping me to speak very clearly, but again, the completely understand that's in most cases you prevailed and you get your fees. We're just wanting to add, in addition to your attorney fees, that the cost of the expert is a part of the full cost of the suit. So when a parent is thinking about the full cost of the suit, if they know that they're absolutely not, even if they do prevail, they'll be in debt thousands of dollars in expert witness fees, may make them less likely to even go to court.
Okay, any further discussion on this bill? Okay, well, we got a motion a second. We'll just do a roll call on this one.
All right, Senator Kagan,
I'd like to associate myself with Senator Washington's comment, vote aye.
Senator Kagan, yes. Senator Augustine. Senator Augustine, yes. Senator Gallion.
Yeah.
Senator Gallion, yes. Senator Watson. Senator Watson, yes. Senator Lewis. Senator Louis Young, yes. Senator Brooks? Yes. Senator Brooks, yes. Senator Carrizo?
Yes.
Senator Carrizo, yes. Senator Hester? Senator Hester, yes. Senator Washington?
Yes.
Senator Washington, yes. Senator Simoneer?
Yeah.
Senator Simoneer, yes. And Senator Feldman?
Yes, 1237 carries unanimously. Before we break, one very small bill, I think a pretty simple bill, Senate Bill 950. April, why don't we just bring this up?
Right, so Senate Bill 950, it's not on the voting list, but it was a late bill. We heard it last week. And because it is a Senate bill and it's cross-file, was also late and got stuck in rules. If this committee is inclined to move it, now would probably be the time. So this is Senate Bill 950, Maryland Zero Emission Electric Vehicle Infrastructure Council membership. The bill alters the composition of the Maryland Zero Emission Electric Vehicle Infrastructure Council to include a representative of both the light duty plug-in electric drive vehicle manufacturer and a representative of a heavy duty plug-in electric drive vehicle manufacturer. Right now, there's just one spot on the council and it doesn't specify light and heavy duty. The thought with this bill, obviously, is with all the clean trucks legislation, et cetera, moving forward, that it would be good to have representation from both the light duty and the heavy duty, since their interests are not always entirely aligned. There are amendments. Senator Quarterman offered at the bill hearing, and it is in your testimony, in the written testimony, if you want to open it up. One amendment would add the Department of General Services to the council as well, just because they've requested it. The other amendment is a conceptual amendment, but there's a drafting error with this bill just because it's drafted to uncodified law. So the amendment would just fix the technical errors and clarify that the bill does not alter current reporting requirements for the council. They're currently required to do a interim report every year, and I think their final report, I believe, is due in 2027.
Okay, so it's largely a couple seats on the board to take into account some of these changes, plus a technical amendment is really what we're talking about on Senator Quarterman's bill.
And
So
potentially amendment to add general services.
and add general services. Okay, so is there a motion just to take up those amendments?
Yeah.
Second, motion and a second. All in favor, will raise your hand on 950, the amendments. Okay, now we've got Senate Bill 950 with those amendments in front of us. A motion, Senator Augustine, Senator second, from Senator Kagan, discussion. Okay, all in favor, raise your hand. All opposed, 950 passes unanimously as amended. That concludes our work for today.